Good afternoon, everybody. I am Michael Waldman. I'm the president of the Brennan Center for Justice at NYU School of Law, and we are so delighted to have you join us for this really important and I think really exciting and interesting conversation on one of the great issues facing our country now and always, who we are and how immigration helps change, build, and define the country. Before we get started, I would like to give you a few housekeeping notes. First of all, we will have lots of time for questions at the end of the conversation. The best way to ask them is to please add them via the question and answer box with which we've all become so familiar at the bottom of the screen on Zoom. The second thing is that we do provide Zoom closed captioning. And for those of you who are joining us for the first time, the Brennan Center for Justice at NYU School of Law is a nonpartisan law and policy institute. We work to strengthen, to revitalize, to defend the systems of democracy and justice in our country so they work for all. We work to try to have our public institutions live up to our ideals and the values we want the country to reflect. We are very excited to host this conversation, as we have so many other times, with our colleagues at the NYU Bradamus Center. And we welcome our colleagues from the Bradamus Center. As I say, we look at the systems of democracy and justice in this country, and we were started by the clerks and family of the late Supreme Court Justice William Brennan a quarter century ago, and bear his name. He was, of course, from a family of immigrants. And we understand, as he understood throughout his time on the court and in public life, that how we welcome new Americans, how we deal with borders, how we deal with the law of immigration is an extraordinarily critical and complex question. Right now, there are 40 million immigrants in the United States. We have the highest share of immigrants living in the United States that we've had in decades, going back to the early 20th century, the time when my family, for example, came to the United States as immigrants to flee oppression and anti-Semitism in Eastern Europe. And just as then, immigration is a complex but also a controversial topic. Anti-immigrant sentiment in some respects is the highest it has been since that early 20th century period. We're going through, once again, a real redefinition of how we look at these issues. Millions, of course, of non-citizens are living in the shadows. There's been demonization and demagoguery in the politics of discussing this issue. And at the same time, a wide and growing understanding of the incredible richness, diversity, and strength that new Americans bring to this country, again, now as before. These are really, really critical topics. Who makes the decisions about how to handle immigration? What should the regime of immigration law be in integrating immigrants into our society? What's the role for the president, who has enormous power here? What's the role for Congress? What's the role for the courts? We all have to wrestle with these. And how can we do all this at a time when Congress has not been able to pass comprehensive immigration reform legislation for decades, something that so many people believe would make such a big, big difference here, resulting, among other things, in enormous workarounds. We have three extraordinary voices to discuss these topics with us today. We're going to be joined and hear from, first of all, Adam Cox. He is the Robert Kindler Professor of Law at NYU Law School of Law. He teaches constitutional law and immigration and other topics. I should note that he is also a member of the board of the Brennan Center for Justice. Cristina Rodríguez is the Leighton Homer Surbeck Professor of Law at Yale Law School, where she teaches constitutional law and theory and immigration law and policy, citizenship theory, and other topics. She is a former member of the Brennan Center board. I should note, I'm intimidated by all these board members lurking around. Professor Rodríguez as well right now is the co-chair of the Presidential Commission on the Supreme Court. that so many of you have heard about, and we're not going to talk about that at all today. And they will be in conversation. They recently published, I should note, a really important book, which will be some of what they're talking about, The President and Immigration Law, which looks at how we got to the current political dynamic. And there's nobody better to dialogue with them about that mix of politics and law than our moderator, Cecilia Munoz, who was the director of the Domestic Policy Council, the domestic policy advisor to President Obama in the White House. She's currently the senior advisor at the New America Foundation and has long been one of the leading expert and passionate voices on immigration and other issues. Cecilia, thank you for taking the mic, and everybody, I'm very much looking forward to hearing what you all have to say.
Thank you so much, Michael. I'm so excited to be here. I'm really grateful to the Brennan Center for hosting this event. This is a really important and timely topic. As we all know, you don't know me to tell you that when presidents set immigration policy, it often comes with controversy. And perhaps no policies have elicited as much outcry, especially over the last 4 years, as the policies of the Trump administration on immigration, barring people from predominantly Muslim countries from entering, separating children, sometimes infants, from their families, declaring a national emergency to fund construction on a border wall. The debate on immigration has hardly subsided. It rages on. And one of the elements of this debate is the question of whether the president or the Congress should control who America lets in and who it kicks out, which is exactly a topic explored in The President and Immigration Law, Cristina and Adam's book, which describes the immense discretion that presidents have to shape enforcement priorities, but also the implications, some of them troubling, for the rule of law. So this is an area that I have worked on for 30 years, including 8 years in the White House. I have questions, and I hope you have questions too. This is really an exciting conversation, a timely conversation. So I hope you will join me in welcoming Cristina Rodríguez and Adam Cox. Welcome to you both, and congratulations on the book. So I'm going to just dive right in. I will say, I found this book totally wonderful. And timely, and the exploration of these questions of presidential authority really couldn't be more topical and timely. So congratulations on the book. And let me start, Cristina, with you, and just to ask you what inspired you to write this book?
First, thank you so much, Cecilia, for being here today. We're so excited to be in conversation with you. We're really also grateful to the Brennan Center for hosting this event. And I'm thrilled to have the opportunity to talk about the book. The immediate cause of us writing the book was President Obama's announcement in 2014 of what we now know as DAPA, Deferred Action for Parents of Americans and Lawful Permanent Residents, a real mouthful of a program, but it was an expansion on a relief program he'd begun 2 years before that, Deferred Action for Childhood Arrivals, DACA, which remains in place. Now, DAPA never went into effect, and that's in part because of the enormous controversy that it generated, which produced litigation run by the state of Texas that led to it ultimately being enjoined by the courts. The reason that prompted us to think about writing this book is because we thought that on all of the sides of the debate, people were misunderstanding the scope of the president's power to implement something like DACA. And as a result, we're also misunderstanding the structure of immigration law and policy, which we thought had profound implications for how we might think about reform and what administrations could do or not do in shaping events on the ground. Adam and I had actually been thinking about these questions about the president's authority since at least 2007, when we were early in our careers and started writing law review pieces on this question of whether it was the president or Congress that had control over the shape of immigration policy. And we thought that even though the conventional understanding is that it's Congress that controls the shape of the polity, that in fact, throughout history, presidential decision-making through a variety of channels has had an enormous effect on how the people think about immigration law and policy and what its shape actually looks like. And so the initiation of DAPA and all of this public salience that had led us to think, that it required the kind of treatment that we give it in this book, which is historically grounded and with a view to the future at the same time.
Thank you. So I thought the discussion of the long history of presidential power over immigration policy in this book was so interesting, and you argue that it's crucial to understanding the present moment. So let me turn to Adam and ask, what does this history tell us? Oops, you're muted.
Sorry about that. The first thing I want to say is I just want to echo Christina's thanks. I'm really thrilled that we're able to be here in conversation with you, and it's so wonderful to be at this event with the Brennan Center. As your introduction noted, I think the events of the last 4 years really made salient for many members of the public, maybe even who had not paid attention to immigration debates in recent time, just how powerful the conflicts are between the president and Congress and how much power the president wields. And that led a lot of folks to see our current moment as either the product of the presidency of Donald Trump, or maybe a little more broadly as the result of our increasingly polarized political environment in Washington, D.C. And we think the history shows that the roots of presidential power are much, much deeper. And we think understanding that history is really crucial to charting a path forward. So, half the book is about the history, and I won't try to summarize it here, but the core argument we make is that 3 20th century developments really solidified the president's role at the center of immigration policymaking. The first development was the rise of deportation as a tool of screening immigrants and regulating their lives. The earliest immigration statutes passed by Congress in the late 19th century, many of them didn't even have deportation provisions. But today, we can see that deportation provisions, in the immigration code are so numerous, they're almost difficult to count, right? So we have a much more probationary immigration system where for essentially all immigrants, even lawful permanent residents, they're always at risk of being placed in deportation proceedings. So that was a really big change in the structure of law. The second change was really a bureaucratic change. It was the growth of a massive deportation bureaucracy, immigration enforcement bureaucracy over the course of the 20th century. Again, to contrast the beginning of the 20th century with the end, we went from a world where, there was limited screening of immigrants at ports of entry. The model people imagine is, you imagine Ellis Island or less well-known Angel Island on the West Coast. But there was no border patrol, very little enforcement along our land borders. And, contrast that with today. You have a Department of Homeland Security, this massive bureaucratic organization that has enforcement resources that dwarf all other federal law enforcement agencies combined. Enforcement resources that were sufficient to deport upwards of 400,000 non-citizens a year. So those two changes, one in the structure of the law and one in the structure of our federal bureaucracy, they collided in the final third of the 20th century with rising rates of unauthorized immigration. And while the causes of those rising rates are complicated and remain contested all the way till today, the consequence was clear, right? We ended up with a world where roughly 11 million non-citizens, half the non-citizens currently living in the US are here in violation of law. And in any system where half the legal subjects are in violation of law, what matters is not the law in the books, it's the enforcement choices made by the executive. And that puts the president really in the driver's seat for so much of immigration policy.
So thank you. This strikes me as this is a hugely important point. And I will say, as a veteran of the Obama administration, this was really the thinking that guided, and the book actually spells this out, right? The development of enforcement priorities, which was an innovation at the time, and the arc, which takes you from our first, frankly, pretty stumbling steps at developing enforcement and implementing enforcement priorities, and then kind of making them stick within the bureaucracy. All of this gets outlined in the book. And of course, it ultimately, that is an arc which ultimately leads you to DACA and to DAPA, right? Which I think is frankly not very well understood. I was thrilled to see it spelled out in the book because those connections are tremendously important. But you also note, right, that these were decisions that didn't come without controversy. And the argument which gets thrown at administrations using this kind of authority is this notion that the president is claiming unlimited executive power. So let me turn back to Cristina. And, you know, given your account and your kind of wrestling with the theory here and the notion that the scale of what has developed has kind of necessitated applying enforcement judgment, and that is power which rightfully belongs to the executive. Does the executive have unlimited power here?
So I think the short answer is that the executive's power is considerable, but it is not unlimited. We happen to think and argue in the book, in line with what you've just said, that neither DACA nor DAPA, for that matter, went from a permissible exercise of enforcement discretion over to an abuse of power. And so we ought to put that into some context. But I want to make 2 points to do that. The first is that you invoked President Trump's travel ban at the beginning. There are parts of the Immigration and Nationality Act that expressly delegate vast powers to the president. And that is the source of the travel ban. It's a vast authority that was given in 1952 to exclude all aliens who the president thought might threaten the United States. And that gives the president a great deal of discretion to patrol the borders. And the last administration used that in a number of ways. But the statute also provides constraints. It establishes what we describe as the domain of enforcement, and therefore the limits on the president's power. So under the last administration, there were efforts to try to push the boundaries of the asylum law, for example. And a lot of those efforts got pushed back in court, rightfully in our view, because of the way that they trenched upon what Congress was very clear about requiring with respect to refugee protection. The world, though, that we're mostly concerned about is the one that you invoked at the beginning, and that's this unclear space where there is not an express delegation of power, but there's very clearly a system of laws for the president to enforce. And it's the interaction of those laws with the facts on the ground that give rise to the discretion that leads to things such as DACA. So Adam described the rise of a shadow system of immigration where you have millions of people who are here without authorization, who are also removable under the law. Well, as you well know, Cecilia, the president and the executive branch have to make choices about how to prioritize enforcement resources. And it's in those choices that we argue Congress has delegated to the executive branch the ability to shape immigration policy through how those choices are defined and then made. We ultimately make the claim that DACA was a manifestation of this enforcement discretion and a kind of improvement of the way in which it had been exercised historically, because it set high-level priorities through a kind of political process that were then imposed evenly across the enforcement domain and allowed the Secretary of Homeland Security to really supervise the enforcement of the immigration laws, which we argue in the book is an enormously important authority that high-level officials have to make sure that resources are used in an efficient fashion, but also in a humane fashion. And that the ability to exercise that kind of leadership and discretion at high levels is the best chance we have for introducing some humanity into this massive enforcement system that Adam described. And I'm curious to think if that's in part how you conceptualized it, or if that is a way to think about the bureaucratic side of it, that it actually also has this humanitarian and policy orientation.
I mean, it really is how we were thinking about it in the Obama administration. And it made me think it would have been really fun to have this conversation while you were working on the book. Adam, I'm going to come to you in a second to talk about how, if you were advising President Biden, how he might want to use his power. But Cristina, I have a follow-up for you because, and I say this like full disclosure, I am not a lawyer, right? I do not possess a law degree. I know a lot about this area of policy. It strikes me as incredibly important, this notion that DACA is sort of understood and is portrayed in the media as a benefits program, and the narrative about how we got to DACA is often portrayed as a bunch of really brave advocates pushed and pushed President Obama until he did what they wanted him to do. And there were and are incredibly brave advocates, and I admire them greatly and have worked with them for many years on the DREAM Act and DACA and other things. But it strikes me as legally and as a policy matter really important that's not a complete picture of what happened. And DACA is not a benefits program, and that matters. Am I right about that? And can you explain why, if I am?
Yes, you're right at the core, which is to say that the choice to forbear from removing people who qualified for DACA is a choice that flows from the power to take care that the law is faithfully executed. It flows from the president and the secretary superintendents over the system of immigration policy. And it is a choice, a systemic one, about how to trade off resources, and to say that in order to have a system that focuses on the right enforcement targets, it's important that we deprioritize those for whom it's not worth expending the resources to remove. Now, the controversy stems from what follows from that, because the administration chose to frame the relief as deferred action. There are a number of regulations that long predated the Obama administration that go back, in some cases, all the way to the Reagan administration, that meant that the recipients of deferred action were then eligible for certain things that could be described as benefits. So to apply for work authorization or certain Social Security benefits. And at least with respect to work authorization, and you can correct me if I'm wrong about this, that's kind of what makes DACA worthwhile to the many hundreds of thousands of people who have applied for it, who've been in the United States since they were children and no other place. And if the theory behind it is that if an administration is not going to remove for a period of time at its discretion a group of people, then those people should have the capacity to sustain their lives and to be productive. And that's what how the work authorization comes in, but it ends up being conflated in the public mind and in the mind of the Attorney General of Texas and members of Congress as giving something that the law, as it's written on the books, was supposed to take away. But in fact, it's part of this really complicated scheme that Adam and I try to explain and show is rooted in a long series of choices taken over time, and not all the creation of the Obama administration.
Thank you. So Adam, let's assume you are advising the new president of the United States. This is a man who is fiercely committed to the rule of law. You and Cristina have established that he has kind of immense power over the implementation of immigration. Is this, like, how do you advise him to use it? Is this something that he should be using aggressively in a muscular way? Is this something that he should cabin the use of? Is it a dangerous, tyrannical instrument? And you're muted.
Sorry, we have a little background noise here, so I keep muting myself when I'm not speaking. I do think the last 4 years led an increasingly large number of folks to worry that this power in the hands of the president runs the risk of being tyrannical, and therefore, should be avoided in a way. And I think the goal of our book is to show that that's not really an option today. The choice that we face is not a choice about whether the president is going to, make these policy choices or whether Congress is going to do so. The choice is whether politically accountable leadership in the White House and these agencies will make important choices about our immigration policies, or whether those choices will be made on an ad hoc basis by lower level agents in the enforcement bureaucracy. And we think it makes much more sense to have those choices made at the top than at the bottom. And that's really a central theme of the book. So if I were advising the Biden administration, I guess there's three things I would want to say. First, and most concretely, of course, there need to be the efforts to shore up these measures that you all undertook during the Obama administration that really did promote the rule of law. Obviously, they've been under attack in the courts over the last 4 years. And so, you can see the Biden administration taking steps to do that, reinforcing DACA to maximize the chance that it survives in the courts. Second, the last 4 years have highlighted that a shortcoming of this kind of power is that it makes it difficult for the president to offer real security to non-citizens. And so I would encourage the administration to think about whether there are other policy tools that can do that. I know that, some, like the technical sounding idea of parole in place, which just means putting non-citizens in a position where they might be able to apply for legal benefits they actually qualify for, was considered during the Obama administration, and I think should be considered by the Biden administration as well, because providing a meaningful path to secure residence is really, really critical. And the third thing is, even in a world where we have these policies in place that promote the rule of law and protect more immigrants from deportation, there's still a massive enforcement machinery that's in operation. And so, an administration does have choices about how it wields those tools. And, two areas where I think there's real room for reform, are both detention in the immigration enforcement system. Detention has been really widely used over the last 2 decades, and increasingly there's evidence that it's not only is it not humane, we've known that for a long time, it's not even cost effective. It doesn't really help the enforcement system. And so moving away from the tremendous use of immigration detention makes sense on a lot of fronts. And then also access to counsel for immigrants who are in deportation proceedings. The Justice Department, unfortunately, across Democratic and Republican administration, has taken a pretty hard line, and defended, even during the Obama administration, defended the idea that young children in deportation proceedings don't need lawyers. And I think it's within the power of the administration to change its thinking about those matters. And so I think those 3 things would be big, important steps for them to take.
I would just quibble with one tiny piece of what you just said, which is that, as I understood the argument on legal representation, it wasn't that kids in asylum proceedings, for example, don't need lawyers, is that the government was not obliged to provide them.
Yes, exactly. I should be clear. The position has been that government provided counsel. It's not required as a matter of either the statute or the Constitution.
Right. But it's also really clear, and I was certainly the view in the Obama administration, and I understand it to be the view in the Biden administration, that the government and everybody else should be moving heaven and earth to make sure that people are represented, especially in asylum proceedings. And that's ultimately in the interest of the process going smoothly, not to mention in the interest of justice.
Exactly.
Yeah. Cristina, back to you. Another way that this conversation frequently plays out is this notion that Congress is broken, it's stuck, it doesn't do what it's supposed to do, and that the gridlock is actually the reason that the president plays such a large role. And obviously, the Obama administration did a lot of what he called using his pen and his phone to find whatever levers were available to him and use those levers in order to advance his goals. But is gridlock really the explanation of what we're talking about here?
So I think there are 2 ways to answer that question. The first is that in the book, Adam and I explore the possibility that this system, where there is vast discretion in the hands of the president and the executive branch, is actually something by design. Not that there was a moment when Congress decided this is how we want things to work, but that it's the kind of accommodation that Congress and the executive branch have worked out over time, because there's an interest in certain constituencies in having a large non-citizen population that performs important functions and maybe even is connected to people who are citizens and permanent residents of the United States, but who can also be easily removed. That's a different way of saying that there is not consensus on the question of what to do about the unauthorized population. I mean, you've been fighting on this question for a long time, since before you were in the White House, and reform has eluded the advocacy community and has eluded Congress. And some of that might have to do with gridlock and polarization, but it's something that also predates the hyper-polarization of our moment and reflects the deep history of ambivalence that we bring to light in the book about immigration law and immigration policy. But that is something that's lamentable. One of the ways that we end the book is to say, in addition to all of the methods that an administration like the Biden one could use to soften the edges of the immigration laws or make them more humane or address the policy issues that are roiling in the debate, is also to turn to Congress and to propose legislation, which of course the administration has done. The Obama administration did the same, and the Bush administration did the same before them. So I'm actually interested in your views about what it would take to get us to that point, because it's not possible to eliminate the discretion in the system without legislation. And there are various ways that legislation could address that discretion and could displace the enforcement logic that Adam so well described from the center of the system, which would be one of our policy objectives, and one I believe that you share. And so maybe I could end by asking you what you think it will take to get from here to there, and if there's anything an administration, a presidency can do to push that forward when much of the problem may in fact be dysfunctions or barriers in Congress itself.
Yeah, it's a great question and a timely one, because we are in a conversation, even right at this moment, Congress and the administration are in a conversation about whether or not there is an opportunity to advance any portion of the of an immigration proposal. The president has put forward a quite ambitious one. But since forever, really, and not just immigration legislation, but any legislation has needed 60 votes in the Senate, and 60 votes is, in a 50-50 Senate is a very tall order on anything, let alone on an issue this difficult. I think the thing which frustrates me the most is also the thing which you hear the president talking about, not just on this issue, but on a whole range of things which are his priorities, which is that there is a mismatch between kind of where the American people are and where the Congress of the United States is, right? You see this playing out in the conversation about whether he's operating in a bipartisan way. And the answer that we've been hearing from the White House is, well, if by bipartisan you mean policies that are supported by Democrats and Republicans in the country, immigration reform is squarely in that category. If by bipartisan you mean that there are Republican votes in the Congress, especially in the Senate, it's not so clear that that's true. And that mismatch is the thing which has plagued anything positive in the immigration space legislatively for at least 20 years. I mean, the first iterations of the immigration reform proposal that we're still working with, still trying to get passed. There was a version passed in the Senate in 2006. We've been working on it since 2000, 2001. It's a long haul, and the difficulty is not a substantive difficulty. It's not like figuring out what the right policy is. It's not whether or not the public supports the kind of proposals that have been presented before the Senate. It's really whether or not the votes are there in the Congress. And so far that hasn't been true. And the question that's being asked now is there a play on legalizing some portion of the undocumented population, Dreamers through the DREAM Act, farm workers, there's a bipartisan proposal on farm workers, people with TPS, potentially essential workers. Like, is there a configuration which can either get you to 60 or can move on a reconciliation package? And that's the question of the moment. And the answer to whether or not there can be movement is whether or not you can get to 60 or you can move it on reconciliation. And the latter question gets to be answered by the Senate parliamentarian if it gets asked by members of the Senate. So that's essentially the situation with respect to moving legislation. But I want to turn the question around a little bit, maybe for either one of you, and that is, so much of this conversation about what authority the executive does and doesn't have is aimed at the situation in which we find ourselves now, in which there are 10 to 11 million undocumented people. We haven't provided a meaningful opportunity for folks to get on the other side of the line to become legal, really since the 1986 Act, and legal immigration hasn't been reformed since 1991. So we're having an enormous conversation about enforcement authority that's aimed at a situation in which we have stuff which is broken, which Congress hasn't fixed in a really long time. What would your recommendations be to a president if, God willing, in a perfect world, we were on the other side of this immigration reform question and we did not have 10 million people living in the United States without immigration status? What if we had less than 2 million people in that situation, or less than 1? would that change the conversation about the president's enforcement authority? Should it? And like, how do you envision a policy regime in that world?
Sure, I'll say maybe a word about it, and then maybe Cristina will also want to chip in. I think it would be tempting in that world to say, oh, we can move away from a role that's significant for the president and just put Congress back in the driver's seat. But I think what we feel like we learned in the book is that there is real value that comes from presidential leadership in the system. And immigration is a space where, you know, the unanticipated and the crisis that can define a moment really necessitates an active role for the president in policymaking. So if we could, you know, solve the problems that plague us today because of the moment we're in, looking forward, what we actually argue for at the end of the book is not so much a reduced role for the president, but a reimagined one. You know, and I think the refugee crisis along our southern border really exemplifies how we should think about the future. Because, you know, while the numbers of immigrants arriving and for the most part seeking asylum don't approach really the numbers who, you know, came without authorization in the 1980s and 1990s. You know, we are really in a different world today where there's not really reason to expect the same high rates of migration that we, you know, had in past decades. There are still nonetheless challenges. And what we need is a regime unlike the one we have today, because today the president's power operates mostly on the back end of the system. There are some important front end powers to block immigrants, like the so-called suspension power that was the basis for President Trump's travel ban. But the president has much less flexibility in managing in a humanitarian fashion crises that arise at the border or elsewhere. And so we would actually argue that what makes sense would be to more explicitly delegate the president that sort of authority, right? If the president had in his pocket the authority to provide some sort of lawful status, even if temporary, to those families arriving at the southern border today, then it wouldn't confront this difficult choice it confronts now, where it you know, has to figure out how to use an asylum system that isn't particularly well equipped to managing the reasons that are leading people to flee their countries, or not use that system and instead turn people away. That's the choice that confronts the administration now, but we think, you know, giving the president a different set of tools would open up a new set of options.
Cristina, anything to add before I turn to questions from the audience?
I would just add two quick things. The first is that to accomplish a lot of what Adam is describing and what we outline at the end of the book, the executive branch requires Congress's help, both to grant legal authorities that it doesn't currently have, but also to shift appropriations away from the enforcement machinery, which might no longer be necessary if the world that you're describing comes to be, to other kinds of programs, protection programs, and other ways of shoring up the legal immigration system and the humanitarian immigration systems. And the president cannot single-handedly do either of those things. But I do also think that a world where you don't have such a large unauthorized population that's been settled through a legalization program or something of that sort is a world where the policy rhetoric can shift, and where we can have a more honest conversation, maybe even across partisan divides, about what immigration ought to look like, what immigration benefits the national interest, what obligation is owed to the people whose lives the United States affects through our foreign policy, what obligation do we owe citizens and permanent residents for reunification. Those kinds of debates that get obscured by an obsessive focus on the rule of law and the fear that the border is being overrun. And we above all would like to eliminate those from the central place that they have in our conversation to have a better kind of immigration debate.
Thank you. So questions that have been coming in through the Q&A link. The first one's really interesting question. I'd love to hear your answer. Does ICE maintain a degree of autonomy from the administration? It's part of the administration, but how does it does it have to do what the president says? How much is it able to exercise its own discretion apart from the president's dictates?
So I could take a crack at that one. One of the themes that runs through the book is that even though we talk a great deal about the power the president and high-level officials have to shape immigration policy, they also have to contend with institutions on the ground. And those institutions like ICE and the enforcement bureaucracy make it so that it's not possible to turn the system on a dime. You know that from your experience. It's very hard to change the way the law is enforced, precisely because it is a set of officials with designated powers and expertise within the executive branch who are actually doing the implementation, not the president, him or herself. And as a result, ICE and other enforcement agents, as well as the states, which are an important part of our discussion too, that play a role in the immigration system, shape the limits on the president's power to move the system. That is not to say that the Secretary of Homeland Security doesn't have the power to direct ICE. The problem during the Obama years, of course, was that it is difficult to translate that direction into the day-to-day practices of people in the field. And that's why, in our view, the administration turned to something like DACA, which was intended to move choices about whether those particular people were going to be removed over to CIS, a different enforcement, a different bureaucracy within Homeland Security, and to set some quasi-rules to govern their behavior as a way of trying to exert that control. So legal authority to control by the secretary exists, but the institutional dynamics don't make it a simple I say and you do kind of relationship.
So that is an excellent segue actually into the next question coming from our participants, which is aimed at me actually, which is that it's important to clarify misunderstandings about DACA's origin, particularly as advocates consider how to work with the Biden administration to exercise discretion effectively. So the questioner asks me to take us into the room and talk about when, how, and why the President Obama made the decision about DACA. And this actually relates, Cristina, to what you were just saying, and to the previous question about the decisions that are made by individual officers within the bureaucracy and this enormous enforcement bureaucracy that Adam described, in that the trajectory which ultimately leads to the decision on DACA, as is recounted in the book really, really well, starts with the DHS, the ICE director, beginning to assert some authority over enforcement priorities in these very tentative initial Morton memos, named for John Morton, who was the ICE director at the time. And the idea was that for the first time, it made sense, given the size of the undocumented population for the executive branch, for the agency, to start using its discretion to choose some folks as priorities for enforcement over other folks who should not be priorities for enforcement. And essentially, there are multiple iterations that are outlined in the book. At the same time, so that this is happening administratively at the same time that the president is trying to get a bipartisan conversation going in the Congress to pass an immigration reform, understanding that the only permanent changes you can make require Congress. But what ends up happening is that DHS's efforts are tentative, and the agency is having a hard time getting its own officials to do what's on paper. Right. So, and I, again, as a person who was involved in these conversations, it was very clear to me that if we tried to get the policy exactly right from the beginning and tried to impose it on the bureaucracy, that we would fail. Right. So this process of iteration, which went on, frankly, for much too long, turns out to be really important to get us both to DACA, which happens in 2012, and Secretary Napolitano sort of recognizes that the efforts have not been succeeding in keeping dreamers who are clearly low priorities out of the deportation caseload. But also, very importantly, that takes us to 2014, which is the enforcement priorities that are announced at the same time as DAPA, in which Secretary Johnson succeeded in getting his guys, the infrastructure to implement. So for the first time, you have ICE officials serving warrants for folks who have been convicted of serious crimes. And if they have family members, undocumented family members in the same home, they're not taking the family members. That's the first time that happens. And that is sort of the result of this, both iteration, but also of, Secretary Johnson's really important maneuvering within the agencies to convince his own rank and file that this is real law enforcement work, that you won't be secondary law enforcement officers, which is how these folks are thought of kind of in the law enforcement architecture, but that you'll be law enforcement officers going after actual bad guys. And that turns out to make a difference in generating compliance, but generating compliance with policy turns out to be an enormously challenging exercise. Okay, there are some questions, a couple of questions aimed at judges and the courts. Why can't we fix the immigration problem by appointing more judges, lawyers, legal aides, representation, other personnel to process cases? And the questioner writes, I have a friend married to a Cuban living in Havana that she's been told there's a waiting list of 100,000 people, the same at the border, don't house people, process them. But so for a long time, particularly the asylum process at the border, advocates have argued, we need to hire more judges. We need the resources for more judges. Is it possible to hire enough judges, enough personnel to meet with the kind of demand that we're facing now?
It's not clear that you can just sort of pour resources into the adjudication system to solve the problems. And I think in order to see why that's the case, first we have to describe a little bit, in more detail what exactly we think the problem is. And I think these questions hit on a couple different problems. So one problem, really is a problem for the deportation system. So the process by which people are placed in deportation proceedings, a process through immigration court before they receive a judgment about whether they're going to be receive an order of deportation. And that system has an enormous backlog, right? It has, over 1 million cases, I think, now pending, and questions about how to fix that. But, making the process go more quickly is not necessarily going to lead to more just and humane outcomes, because, especially for folks who are placed in deportation proceedings who are currently living in the United States, the people who are most likely to have significant connections to family members, communities here, they often have very little recourse to relief in immigration court. So making the proceedings go faster will just mean the faster receipt of an order of deportation. And that's because of a couple of big changes in the 20th century. One was just, laws in the books that made every person who entered without authorization deportable for the rest of their lives. So just your presence in the country makes you deportable. And then changes in the mid-90s by Congress to take away pathways to relief for many of those people who are here without authorization. And so, we talk a little bit about this in the book, but you often see conversations hoping that a little institutional tweak will result in some magical fix of some deep-seated problems. And I think, I think the story of the immigration courts really highlights the fact that we're going to have to change substantive laws, not just, pour more resources into these institutions in order to really solve the problems.
Right. I completely agree. And in some ways, this is a guidance for the advocacy community that, as important as it is to put the kind of pressure that they are putting on the president to do as much as he can is insufficient to fix what's wrong.
Yes. Yeah.
And
I think, to echo what you're saying, it excites me a lot when advocates in the reform community focus on particular outcomes, not just institutions. So, we talked earlier about detention. I think, deciding were it possible to just abolish ICE, given the longstanding law enforcement culture that exists, is likely to lead to the replication of that culture in some other institution. That's what happened when the INS was abolished, and ICE succeeded. In fact, in some ways, ICE reified the law enforcement culture that had existed in the INS. And so a project to just change the institution without a concrete idea about what we want. But if we say what we'd like to do is let's try to eliminate as much as possible immigration detention. That's a project where you can imagine institutional changes that would be necessary to get you there. But I think the focus is on a goal that we can be confident would, improve the system if we reached it.
Thank you. So I'll turn now to a question from a DACA recipient who's part of our audience. He or she writes, I'm a DACA recipient. My family was hopeful that with a new executive branch and shifted power in the legislature, more positive immigration reform would benefit our status and situation. What do you think the president and Congress can do to either A, create any tangible change for DACA recipients, B, address the fears of many other citizens who may be frustrated about extending more rights to the DACA and undocumented community?
I think that the administration is trying to take the first step by fortifying DACA, as both you and Adam have described, which is to put it on the strongest legal footing it can be on. I think one thing to keep that is on the horizon to keep in mind is that the state of Texas has filed a lawsuit challenging the legality of DACA itself. That's something that courts were mostly able to avoid on the merits for the entirety of the Obama years. But for whatever reason, it took Texas a few years to decide to file this lawsuit. But now the Biden administration is contending with the possibility that the particular Supreme Court that we have might not, in fact, share our view of why DACA is authorized. And in its decision last term, basically rejecting the Trump administration's efforts to rescind DACA, even though that was a momentary victory, we think that opinion actually lays out a path to invalidating what we've already described in this conversation as one of DACA's core features, and that is the authorization to work in the United States. And so that is the immediate and medium-term battle that the administration is going to have to fight. And it will take a year or two, at least, I think, for that to be resolved and for us to have a clear sense of what the Supreme Court thinks about DACA as a program. And then beyond that, Adam has described some other administrative tools that might be available to provide forms of relief, at least forbearance from removal, if not the opportunity to apply for immigration benefits for which people qualify. But as you well know, using any one of those tools can produce a political backlash. And as I think we can say from the way the Biden administration has reacted to events on the border and concerns about criticisms that it's allowing too many people to come to the border and claim asylum, whether those are founded or not, that there will be caution in using some of those tools for fear of distracting people from agenda items that are maybe more important and that are not served by having political controversy about some new innovation in the use of administrative power. And so that's something of a pessimistic answer, except to say that I think it's very clear this administration is committed to defending DACA, and if that succeeds, to possibly expanding it once the legal authority seems firm. And our long-term view is that something like DACA, which we describe as one of the major immigration reform moves of a generation, even though it was not a legislative reform, might in fact be to change the way people talk about immigration. I think it's changed the way people understand the equities of the dreamers. And by people, I mean the public at large. And that policies like DACA might help to reshape the political landscape a bit so that a congressional legalization seems like a no-brainer as opposed to something that's flouting the rule of law. And that's where we hope we can arrive, and it will take some time to get there.
So a last question related to this in the time that we have remaining. So what does that say about, again, to advocates who are really focused on the use of executive authority to provide urgently needed relief for people who badly need relief? Like, what does that tell us? Adam or Cristina, have I stumped you?
I think it tells us that a lot, as Adam described, it is worth putting energy into the bigger picture and the longer term, even though in order to get actual relief, sometimes you have to focus on where the immediate power rests, and that is with the executive branch, but also not to have demands that are great, but not expectations that are overly high, because politics is inevitably going to shape the choices that administration makes about which levers to use and which not. And those politics are time sensitive and contingent on whatever's happening in a given moment. So that's also an argument for hanging in there, right? And finding your opening when the politics align to try something bold. But I think this litigation about DACA is kind of shaping the parameters at the moment.
Thank you. Any last word, Adam?
No, that's exactly what I would have said.
All right, we are reaching closing time. I'm just going to plug the book. It's right here because of its excellence. And thank you for being part of this wonderful conversation today. Thank you, Cristina and Adam especially. We wish you the best of luck with this wonderful book. Thanks to our audience for all of your questions. We got to a lot of them. We didn't get to all of them. I wish we had gotten to get to them all. Thank you very much to our production partner, the NYU Broadus Center. And a quick note from the Brennan Center before we leave you: you can stay up to date on key issues that affect our democracy with weekly analysis and insight from Brennan experts. If you're watching the chat, you can see some links so that you can sign up for the briefing newsletter at brennancenter.org/briefing. We look forward to seeing you at the next event, and be sure to register at brennancenter.org/events. Thank you so much for supporting the work of the Brennan Center. There are heroes at work in this place. And we so appreciate your participating in this wonderful conversation. And with that, we will close. Thank you all very much.